Perfect timing, sir.
Right, we are starting. Okay, great. Welcome everybody to Senate Economic Development, Housing, and General Affairs. And we are here live. It is Tuesday, May 20th. Yikes. Time marches on, and we are making a decision this morning about whether to concur or not concur on S-125, one of our two labor bills. And the judiciary is asked to testify briefly, which we're going to have briefly, and then a response by the SEA, and then we're going to go into deliberation about whether to concur or not right after. So welcome. Terry, introduce yourself and share with us how the court is feeling.
Senator Clarkson, thank you so much for the opportunity. Terry Corson, State Court Administrator. Good morning, and I really appreciate this last minute chance to come. We had actually, when you all had the bill before the crossover, requested the chance. There wasn't, due to time constraints of the crossover, the opportunity for us to come and present our testimony then. Senator Clarkson encouraged us to make our views known in the House, which we did. I did provide two memoranda that we had submitted to the House that addressed our issues with the information known at that time. In a nutshell, the section that we're concerned with is Section 5 of S-125, which purports to remove supervisory employees from the list of exempt employees in the judiciary. Historically, supervisory employees, along with managerial employees, judicial officers, confidential employees, attorneys, and law clerks, have been exempt from the bargaining unit in the judiciary since 1977. This would propose to strike supervisory employees from that list. When we learned of that, I learned that we have just 4 supervisory employees in the judiciary. And our question was, why would you have a separate bargaining unit, a separate contract potentially for employees? And we testified to that effect in House General and Housing. And it came out through Mr. Howard's testimony that the intent was not to limit this opening the door to just the 4 supervisory employees. A representation was made that this was being made on behalf of court operations managers, of which there are 24 in the judiciary. And court operations managers, in my view, certainly are managerial employees. So the question is, how could they be included as supervisory employees? It was explained to me that there would be an attempt to reclassify them as supervisory employees instead of managerial employees, to make them potentially subject to seeking collective bargaining. I learned when I was asked, do the supervisory employees support this? I learned in talking with the 4 supervisory employees, they not only did they not support it, they were not even aware of it. They said to me, we didn't even know this was being proposed, and we do not support it. And I relayed that to the House committee when it came out that corporations managers were part of the intent with this approach. I also spoke with the court operations managers as a group and learned the same thing. They indicated that they were not aware of this, they did not support it, and they very much opposed the idea of them being considered not managerial employees, which is what, if you look at their job description, and the second supplemental memorandum includes their job description, is, in my view, again, straightforward managerial. So they were also very upset about the idea that the work that they do, and court operations managers are responsible for either criminal, civil, family, or probate divisions within the courthouses. In each courthouse, there is a court operation manager who runs the day-to-day operations of that courthouse. In the smaller courthouses, such as in Grand Isle, there's a court operations manager in one, typically in the smaller courthouses. In the larger courthouses, there might be a criminal court operations manager. There could be a family court operations manager. In Washington County, for example, where we are, Donna Waters is the court operations manager for the civil and probate division at the Washington County Courthouse here in Montpelier. And Sherry Goldstein is the criminal and family court operations manager at the Berry Courthouse in Washington County. They are responsible for the day-to-day operations of the courthouse. They're the heads of their divisions, which is taken verbatim from the definition of managerial employee. So their opposition to this is based on those grounds. And when we learned that, we did submit the supplemental memorandum and asked for the opportunity to testify, and they in fact wanted to testify. There was not time for that. The vote was taken at that point in time. The one justification for saying, oh, supervisory employees should be changed after 50 years to be exempt is the executive branch, their supervisory employees are not exempt. They're part of the bargaining unit. We point out that the management structure in the executive branch is far different than the management structure in this far smaller judicial branch. There are, my understanding, 10,000 employees in the executive branch, 1,200 supervisory employees. In the judicial branch, we have 400 employees, and we have 4 supervisory employees. The municipal employees, like the judiciary, supervisory employees are exempt. They continue to be exempt. I look at Burlington, which has 500 employees. Their supervisory employees are exempt. Their management structure, like ours, is far less stratified than in the executive branch. So my, I guess, response to saying, well, we need to be on par with the executive branch, it's a far different management structure, far more stratified and diverse on the executive branch than in the judicial branch. So that's another reason why we oppose it. We also learned, and thanks to Sophie with her side-by-side, also something that's been added. Section 5 is what we are opposed to for these reasons. On behalf of the supervisory employees and the court operations managers, that's here. I'm representing what they have indicated to me and why they are opposed to this. Another thing that's been added is the decertification part that changes the threshold. Right now, it's the same threshold. If you want to certify, it's 30%. If you want to decertify, it's 30%. This proposed amendment would raise the threshold to make it far harder to decertify. You get 50% plus 1. I learned, Sophie kindly shared that. There's now been a Section 5C added that would add that increased threshold for decertification in the judicial branch. We weren't aware of that when we testified at the House, but I, for the record, say we oppose that as well. How is that fair to make it harder to have a higher threshold to decertify than to certify? So I wanted to make mention of that as well.
Thank you. Thank you. And thank you, Joe, for being present for if there are any questions.
I do have a question.
Randy.
And that is, as you look at the jobs that the supervisory employees do, how does it differ from what the managerial employees do in the courthouse? And first, and then second, why do you believe that they should be considered non-union employees?
Exempt, to remain as exempt as they have been historically for 50 years.
Aside from the history, but why?
Yeah, my understanding, and Joe McNeil, who's a labor relations lawyer, I am not, I can explain the history and the criteria far better than I. My understanding is that they fulfill a managerial role. They supervise other employees. They're involved with the budget. They're involved with personnel matters. They fulfill management.
Well, you mentioned you only have 4, but you have, what is it, 14 or 20 something rather?
24 court operations managers.
So 24 court
managerial
operations
court
managers.
Yes.
And how do they differ from the court managers?
The supervisors? Well, the court operations managers are heads of divisions. Again, whether it's a criminal division, civil, family, probate, or more than one, depending if it's smaller. The supervisory employees do not oversee a division, if you will. It varies. There's 4 of them. One of them works in finance, and they oversee finance employees. That person supervises finance employees within the that finance and management division. 2 of the other ones are involved in courthouse security, and one of them oversees, for example, the courthouse security personnel at the Costello Courthouse. The other one oversees their statewide court security officers that, for example, if there's somebody that calls in sick in Bennington and there's a jury trial, we don't want to have to cancel that. So there are statewide court security officers going to be assigned to fill in to ensure court operations. So that person oversees the statewide, if you will. And then the 4th one is in tech. and supervises the help desk personnel. So it kind of varies, it's just the four. And it was a position, from what I understand, opened up, it was an opportunity for them to be promoted to, and they would be supervising when you look at the management structure, because they're supervising employees, they fit within the supervisory personnel, description. So that's how those came about, but the primary thing is they manage and supervise other employees versus the traditional non-management who would not be supervising others.
Thomas has a
My
question.
understanding of the language is it doesn't, if this passes, they will not all of a sudden be unionized, right? They would still have to go through that. And I think I heard you say that, but your understanding is they have no interest in unionizing. Is that correct?
Well, at least when we met with the group, they were very much opposed, but they were also opposed to the process and here's my understanding, and Joe can elaborate. But
We don't have time, sadly, for too much elaboration, because we're gonna need to get to discuss this together in about 10 minutes.
okay,
So,
but you're correct. It's not like, okay, passing this bill means that they're union or not union. But there's something where basically there's a card that can be turned in, and if basically it's 30%. So if you're talking about court operations managers, 7. If 7 can be convinced to turn in a card to open the door, no, then that triggers this whole process for the Vermont Labor Relations Board, where it would have to be determined whether they're supervisory employees or managerial employees. Time, expense, and from what I understand and this is coming from the court operations managers who have more experience than I do in terms of union efforts within the courts, has already led to divisiveness and stress. And our court personnel have been out straight with whether they're staff or management. You've heard about the backlogs, you've heard about everything that we've overcome, the challenges from the pandemic, electronic filing, remote hearings, et cetera. Great position to go forward, and to have something come in now that's going to, in their mind, they say it's going to take us away from our management responsibilities to have to deal with this whole now proving that we are managerial versus supervisory employees. There's a whole process the Vermont Labor Relations Board,
right,
we're
that
familiar
they'll
with the
go
delays
through.
there.
So,
And then
Terry,
sorry.
I'm just gonna I'm just,
Okay.
in the interest of time, because our time is a little tight. Joe, you said you wanted to speak, and then I'm gonna turn to VSEA.
So, sorry.
Yeah, Terry, thank you.
Thank you very much, Luther. The only thing that I would add right now to the conversation is
Joe, just for the record.
For the record, say your name.
yes, for the record, my name is Joseph McNeil. I work with McNeil, Eddy and Sheen and advise the judiciary on labor relations matters. So the senator asked a question about the difference between supervisory and managerial, and the judiciary takes the view that the court operations managers are truly managerial. In addition to supervising personnel, they also assist the judiciary in the developing its policy, that involved in critical decision making within the judiciary as to the operations of the various courthouses. That requires independent judgment, discretion, significant expertise. And that's why the judiciary believes that this process could create a division of loyalty between the folks that were hired for the purpose of providing management direction to the judiciary, and instead they would be serving two masters. I'm very picky. I apologize, but that's the difference. But an answer.
Thanks, Joe, it's thank you. Your connection is less than perfect. I'm going to turn now to VSEA, and you can, Terry, you can stay there. We can have an open conversation here. Steve and Tom.
Sure. Thank you, Madam Chair. And I really appreciate the opportunity to speak. This is extraordinarily, Steve Howard, I'm the Executive Director of the VSEA. This is very, almost unprecedented and extraordinarily late in the process. And I really am pleased that in both versions of the bill, the issue of the supervisory unit is not in dispute between the two bodies, as adopted by both bodies in a bipartisan vote after hours of testimony. I would say that I just want to say a few things really quickly. We are trying to figure out why the management of the judiciary is so against allowing people to vote in a democratic vote, in a secret vote, in their kitchen, with the ballots mailed to their home, without their manager who could fire them on the spot, asking them what they think about the bill. Now, we've obviously had different conversations with folks who might be in the unit than the management's had. Otherwise, we wouldn't have pursued this. But in the end, if they want to vote no, they can. If the vote is to form a union and that is successful, nobody is forced to be in the union. They do not have to be in the union. So if somebody doesn't want to be, they cannot be. Our concern is that there is a history with the judiciary that really, the only thing we can really figure out as to why they're spending thousands of dollars, taxpayers' dollars, to fight this and putting so much energy here at the last second into fighting this is because there's a history of misclassification in the judiciary. And I think their concern is that if we get before the labor board, in which we will propose, after reviewing job descriptions, who we think should be in the unit, the management will have an opportunity to propose who they think should be in the unit, and the quasi-judicial independent labor board appointed by Phil Scott, Governor Scott, will decide who's right. And just to give you an example of what we're talking about, I have a decision from the VLRB about the misclassification of temporary employees in the judiciary. And I would just point to the section where the judiciary is ordered to include these employees in the bargaining unit. They were misclassified as temporary employees. We think that's really what the judiciary's concern is, that the VLRB is going to find that there are managerial positions that are misclassified. So just to give you an example of how that decision will come down from the VLRB, it's a pretty normal process, but to be misclassified means you were denied health care, sick days, progressive discipline, all sorts of rights. So we believe strongly that that is an issue that the VLRB has managed in the past and will continue to manage. 50 years of precedent in the in the executive branch. None of the concerns that Ms. Corsones or Mr. McNeil raised have been an issue over the last 50 years. The other thing I just want to clarify, we have not decided who we think should be in the bargaining. We will review the court managers. We will look at all of the non-managerial positions and decide who we think should be in the bargaining unit, who we want to propose for a bargaining unit. We have not said that court managers would be in the bargaining unit. We said maybe we will take a look at those job descriptions, and our legal counsel will advise us as to whether or not we should include them in the bargaining unit. But if only 4 supervisors exist in the judiciary, which we doubt, our members who, by the way, are carrying the burden of the backlog, mostly on their shoulders, they doubt that there's only 4. But if there's only 4, those 4 people have rights and should be able to vote on whether they want a union. So at this very late hour, we urge you to stand by the vote of the state Senate to include that in the bill, and stand by the bipartisan vote in the House to include that in the bill. It's about one thing: allowing these people, these employees, whether they're 4 or whether there's 24, to vote in the privacy of their kitchen without their manager, who could fire them at any moment, staring them down and asking them how they feel about the bill. So I think I'll leave it at that, and happy to answer any questions you might have.
Thank you. Okay, Kay should, I hope, will be here any minute. Any other last questions? David, Randy, Tom? Okay, so we have 125 in front of us, and we are being asked to either concur or not concur with the House proposals of amendment, which are which we have reviewed with Sophie, and which primarily deletes the certified payroll and adds the decertification for opportunity for raises the bar up to 50% plus 1 with all the other unions. So that is what is in front of us at the moment in terms of concurrence or non-concurrence. What are people feeling?
Should Terry step away?
Oh, I feel like I should step away. I don't want to.
You know, you're welcome. to stay or not stay?
Oh, no, I'll stay, I just didn't want to.
Yeah, thanks. Gentlemen, Keisha, are you still with us or are you actually walking in? Ah, you're still in the car.
I'm another 5 or so minutes out. So I can stay
Okay.
on video if the chair allows for that to qualify as a vote.
For committee votes, it absolutely qualifies. And, so how is the committee feeling?
I'll go first if you want.
Yeah, sure.
Okay, great. So, I'm in a union. My father was in a union. My wife's in a union. Her father was in a union. I've seen the benefits of unions. They have gotten me to where they have been in my corner in many different ways, and I do support this bill. So I think giving them the option to form a union is something that as a core value, is important for the proletariat to be able to organize collectively to negotiate for better terms. I do support that. I will say on the decertification, I think it's a little high. I think 40% might be more reasonable, but I'll support this 50+1. I'm just ultimately thinking that it's heading towards the rocks, so to speak, or we're already on the rocks. And I liked your idea earlier in the session at 40%. I thought it was raising it, so making it a little more difficult, but I can support the 50+1 because I don't think it's going to be unfair to the unionized organizers.
I want to think about what I've heard. I want to reread the materials
Well,
before making a decision. I don't want to make a decision right now in 5 minutes, having heard two different sides of an issue without thinking about it. So I do not want to make a decision today.
okay, so my concern is we put this off. We were going to make a decision to concur or not concur on Friday. You two have a conference committee tomorrow morning.
Mhm.
And so we do need to make a decision because if we don't concur, we need to go into conference. So, we don't have a lot of time.
Well, I
So-
think we're going to take the time, from my perspective.
You'd like to
I'm not going to
take
make a snap decision,
Okay,
nor
Dave,
am I going to be forced into one.
okay, then I will be asking you if, for us to consider, and we will hopefully make a decision tomorrow morning after you get back from your conference committee before we go on the floor. Dave, where are you?
Yeah, so I agree with what Randy says about, we need to consider what we just heard. But
Okay.
fundamentally, I understand the need to raise the decertification to 50% so you don't serpentine back and forth
Right.
at 30. Is it 50, the perfect number? I don't know, but I'll leave it at that for right now. And then in regards to the judiciary, just because we give them the opportunity to unionize, it's up to them to decide if they want to or not. So anyway, I want to think about it. It'll take less than 24 hours
Okay,
and we can reconvene and
great.
have a
So my question to the conferees for tomorrow morning on S51, you have a meeting at 9. It's an organizing meeting, right? Are you
I don't know
going
what
to
it
do
is. There's no, it just says it's a meeting. There's no.
Okay, so have you met yet?
No.
Okay, so my guess is it will be fairly brief. I would like to take, if you would be kind enough to please come back here after you have that conference committee. I'd like to reconvene here at 9:30, ish, you know, as soon as
Madam Chair?
that.
Conference committee's
Yes,
over.
Keisha,
I, really appreciate the conversation. Before we decide if we're gonna move the vote to tomorrow, can we do a process check? Or does that mean we're passing over it today? And can we run the math out on this?
so I think I've had a request from the vice chair of the committee, at which I'm honoring, to take the vote tomorrow. Happy to pass over it today. If you'd be kind enough to represent that, Keisha, on the floor, given that you had done the floor work on this bill. Let's pass over it for today, but I'd like to take a vote on it tomorrow morning after the conference committee at 9:30-ish. As soon.
Okay, so it would be up on the floor at 10 a.m. tomorrow.
Right.
So if we take second reading tomorrow, we take third reading on Thursday. Is the committee willing to ask for a rule suspension just to move it along? Because we just don't know what's going to happen next week.
We don't, it's correct. But if we concur, if the vote is to concur, there is no third reading.
Oh, good. Okay.
Okay?
Okay.
So, thank you, Terry and Joe, for making yourselves available. Thank you, Steve and Tom, for making yourselves available at the last minute. We really appreciate, and I think.
So then, Madam Chair, could we,
Yeah.
if we vote to concur, is there a way we could do a rule suspension tomorrow to move it along? I feel like we're doing the courtesy of an extra 24 hours to review.
I don't think we need.
Well, I don't remember. I mean, the VSBA stuff has gone through to like the veto session. And, you know, I feel like somehow it always comes down to the wire for these issues. And I just feel more comfortable if we could seek a rule suspension to keep it moving.
So let me chat with Bloomer, but I don't think we'll need if we concur, I don't think we'll need a rule suspension. It will just go straight to the governor.
It's a different conversation if we
I guess
amend.
we could.
If we amend, if we
No,
make any.
yeah, okay.
You're absolutely
Okay,
right.
I mean, right, okay.
Right. So, that is the plan, that is the hope. And, we will vote on this tomorrow morning after this initial conference committee. I'm happy to delay it. I was hoping to get it out today, but, I am honoring Randy's request. So let's turn to other things. Thank you, Terry. Thank you, Joe. Keisha, we'll see you in a minute. Yeah. So Kathy, are we ready to?
Yeah, Kathy Keenan, I've spoken with her.
You've spoken, okay, great. I'd like to, have our, so we voted, and I believe, David, we voted on our other two nominees, because I want to just represent this to Brian, so we get this on the calendar for Friday. So would you be kind enough to share with us about Kathy? And I have finally connected with Lindsay Curley, who's back from being out of town, and so I will chat with her today. So thoughts on Kathy, because I'd love to vote on Kathy.
Kathy, for those of you who may not know her, she's a longtime representative from St. Albans City in the House. I don't know how many years, but quite a number of years.
A long time. She was chair of House.
A long time. She was nominated to appear for reappointment to this board, and she's been on the board for I think she said it's either her third or fourth
Quite a while.
term, so she's been on it for a while, is interested in it, is capable of serving on it. She's very well respected on both sides of the aisle, and recommend her highly.
Great, terrific. Thank you. Anybody else ready to chat? Thomas.
So, two of the three I spoke to on the phone, and the
Great.
names are on a sheet that I handed Heidi, and I cannot remember both of them.
You had David, Jeffrey, and Corey.
So Mr. Beecher, Jeff, I have not heard back from. I only had his email and I emailed him. The other two, I did have a nice conversation with both of them. They both want to continue in their respective roles in the Vermont Labor Board and the other one. And they, in my stock questions, they answered them quite well. So I support their reconfirmation.
So Corey was Board of Liquor and Lottery,
Yes.
and David is State Labor Relations Board.
Yeah.
And Jeffrey is, and Emily,
It's the Electricians Licensing Board. He has not
Yes.
responded to my email.
Okay, great. Well, do we have a phone number for him?
No, the governor's office has just an email for what people didn't get out there.
Okay, so maybe we could call this phone number.
I'll work on that.
You're a whiz at that. So we're ready to consider 4 people at the moment.
Allison?
Sorry, hold on one sec, Keisha.
Okay.
Keisha, did you have an opportunity to talk to, Emily?
I talked to Sabina this morning. I was wondering if it would make, I don't know if her position is underlined, but it might make sense to do a floor report. So she was going to draft me something, but I can halt her from doing that if we're
Right.
not.
I will I will ask, I'll ask, she's it's a funny spot. You're right. It's sort of between being a commissioner. She's a direct report to the governor. So, she may well be underlined. We'll check with Bloomer and Collmore.
Okay, but I do think we should confirm her, so I talked to her. I reached out to Emily Wadhams and I haven't heard back. I wonder if the word of, our VHCB leaders is enough or not, but I haven't heard back in a few days.
Let's give it another day. I need another day on Lindsay because Lindsay's just gotten back to me. So, okay, so I think maybe tomorrow let's do a vote on all these unless we're ready to vote. We could certainly vote right now on the people we've all talked to.
Yeah, we do that.
Why don't we do that and get those off to Bloomer? So did you guys take your letters up last week? Yes.
Yes. I didn't take letters up. Was I supposed to do that?
No, yeah, I don't, you had
I don't think I
Gary.
did either. I think it's on my desk.
Okay, yes, it is on your desk, Keisha. Ha, you're right. So let us
Got this letter
then,
first.
David, if you are able, let's do a vote on Corey Matthau and David Boulanger and Sabina Haskell and Kathy Keenan.
We don't have a form, but here, I'm just printing one of the, printing one now.
Okay, we can do 4 votes on one if that's okay. And then we need to take the letters up to Bloomer's office.
I just have their names on it, but write them on like you did, I guess.
Thank you.
Okay, we have,
Mine aren't underlined. I don't need a speech, right?
right, correct.
Okay.
They get done in a group. So, David, would you be we're gonna do Corey Matthau, David Boulanger, Sabina Haskell, and Kathy Keenan. For,
Okay, I'll fill in the full names.
Okay,
in just a moment.
terrific.
So, ready to vote, Madam Chair?
I would move, I'd ask for motion to move them as a slate.
So moved.
Great. Great.
Very
Call
good.
the roll, please, Mr.
Senator
Clerk.
Brock,
Yes.
Senator Chivden.
Yes.
Senator Rom Hinsdale,
Yes.
Senator Weeks, yes. Senator Clarkson,
Yes. Great. So we will take those up. If people could take up those letters to the secretary's office, that would be great. And we have still, we're being called to the floor. We still have Bryant Plant, and we'll just go through these and remind everybody. But Rhonda Shippey, Randy, you've got Rhonda Shippey and William Johnson,
I have Rhonda Shippey. Who's Rhonda
Yeah.
Shippey?
member of VITA. She's,
I don't remember that at all, but
she lives in Morgan. I don't know. Okay, well, I've got your name by it, and William Johnson, who's the electricians licensing board. David
Right.
Weeks, you've got Kevin Gordon,
I do.
and I've got
I have the
Brian
other one.
Plant, who I need.
On Friday, they were assigned.
We each took one on Friday. We've done Amy and Lindsay I've got, and we've got Gary McQuiston done. And you took Gary McQuiston's up, or no, David Weeks, you
That's me.
took
I
Gary's
believe I
up.
did. I'll check. I've
Okay,
got
great.
another copy.
Okay, what's the other one besides Rhonda Shippey?
Rhonda Shippey, and you also took William Johnson, who's Isle Lamont. who
Yeah, I
was-
remember that.
And he's a member of the electricians licensing board.
And Rhonda lives in where?
Rhonda lives in Morgan.
Morgan. Yeah, I do remember now.
Great, okay.
Can I say something?
What, my dear? Okay,
I don't know if H479 made it out of
It
Senate
did.
Natural on Friday. I'll ask. It did? Okay.
Right.
Well, anyway, I have sent the four members of the committee who voted for the bill different sections that they might want to report. So I know Randy asked for access, so just tell me if you need access from a different email. But I've put your initials in the sections where I thought you might want to report, and half of them at least are kind of, this is the same as S127, so no change. David, I'm happy to.
Send it as a Google Docs. This is it right here.
Google
I just gave him a printed copy of your document, Keisha.
Oh, thanks. Okay, great. So, Senator Brock, for example, I have you doing the credit reporting section only because you spent so much time making sure it was something you could live with. But it was just, these are thoughts to keep them clumped together. And David, if you wanted to report something, I'm open to that. I just sort of didn't have the brain power to get that detailed. So it's up to you all. Just let me know if you do not approve of the sections you're reporting.
Right, we will look at
We will look
that,
at them.
and we're going